It is my profound and extreme pleasure to introduce our keynote speaker for this year's conference, Common Ground, How Intellectual Property Unites Creators and Innovators. It is, of course, the inestimable Richard Epstein. Lawrence A. Tisch, Professor of Law at NYU, and James Parker Hill, Distinguished Service Professor Emeritus of Chicago Law School.
Now, I'm supposed to talk about today a topic called Common Ground, How Intellectual Property Unites Creators and Investors. And so what I guess I'm supposed to do is to explain why I don't understand the title of the talk, and therefore I'm not quite sure what the theme of the conference is. And let me see if I can kind of indicate what my problems are with the title, and then see why it actually has some deep philosophical implications for the way in which we organize this field. Well, the first thing I did when I looked at the titles, I stared at it and I tried to say, what's a creator and what's an innovator? And indeed, not only did I do this, but I did some detailed empirical research by asking my children and my assistant exactly what the difference was between a creator and an innovator. And it turns out that they could not find any kind of ordinary language differences between the two of them. And so that led me to the question of why is it that Adam has put this particular thing in the title? And the answer that I now discover is that creators are artistic and that innovators turn out to be patents. And this seems to me to be a very serious categorical mistake and in terms of the way in which you think about the problem, and let me explain why. In the introduction that Adam gave of me, he said, this is a man who sort of is an intellectual dilettante. He goes from area to area. And the point of doing all of this is to see the ways in which general principles manage to apply across a large number of cases. And in fact, if you're trying to talk about how you organize systems of property and contract law, the first thing that you want to do is to have a general theory which is not overly specific with respect to particular resources or particular kinds of people. So that when you are starting to talk about contract, for example, there's a certain intellectual power and necessity in organizing the subject in the following way. The only people who work in this particular area are Mr. A and Miss B. They have no particular identities of any sort, kind of description. And what you do is you figure out how these anonymous souls manage to work themselves through a system, leaving it for them in their own private lives to figure out exactly what the term and conditions of the particular contracts turn out to be. And by using these high levels of abstraction, what it does give you is the advantage of a degree of generalization that you won't get when you start with talking about a contract theory as a matter of high degrees of particularity. And the same thing is true with respect to property. One of the reasons why the successful property instruction starts with white acre and with black acre and occasionally goes to brown and green acre is that what you're doing is you're now announcing that the theory that you have with respect to the acquisition of property is sufficiently general that it doesn't depend upon anything in particular about the property, but it only depends upon property as a class, which is land or water or some other kind of resource. And it's exactly these generalizations that help. And so when you start now to say that we're going to start talking about innovators and creators and put them into separate boxes, the first question you actually have to really ask about it is, do you want to keep them in separate boxes or do you want to put them into the same boxes? And the answer is you want to do both. Because what you need is a general theory of property law and a general theory of contract law to set the stage. And then what you have to do is to ask the next question is, as people start to play this game out in their own private choices, something that Mark Schultz sort of emphasized earlier today, how are they going to differentiate themselves voluntarily into different kinds of roles which will start to work by different kinds of mechanisms? And so what I'm going to do today is to talk a little bit about this particular kind of cycle. We are going to talk obviously about patents and copyrights, but as I think became perfectly clear from the discussion this morning, trade secrets is an extremely important component of this business. Trade names and trademarks are there, and that in many cases what's happened is that this modern firm, when it tries to maximize all of its assets, has to have an integrated portfolio of multiple kinds of things, and that means it's going to have multiple strategies with respect to the way in which they deploy it. Now, the second problem I think that you have to worry about is the simple question of when you put all of this stuff together, why is it that you have to tie innovation and creativity to intellectual property at all? It's not that it doesn't have a relationship, but I think, in fact, if you start to look, there are many kinds of innovators in technology who not necessarily rely upon or depend upon intellectual property. There are lots of creative people who put together shows and various kinds of adventures, and they don't have themselves engaged in copyrights. So that you're kind of looking at what the landscape is about. You have innovators without property, you have innovators with property, you have creators with and without property. Putting the whole thing together, the question that you want to ask first is, does the property arrangement actually dominate? And the sort of voluntary arrangement. And the word unite, of course, at this point now becomes highly problematic, Adam, because when you're starting to talk about property uniting things, it's not property that unites people, it's contracts that unite people one way or another, and that property are the things over which the contracts themselves can take place. And so what you're trying to do now is to figure out how all of these things start to organize and develop some kind of an organizational framework in which to do this. And when I think the way in which I'm going to do this is to take a very simple method, which is to ask first the question, something about the life cycle associated with either creation or innovation, and then try to talk about the various kinds of property and contract relationships that exist with respect to do this. And now the first thing to note is that generally speaking, when you talk about innovation, there are two ways in which you can try to drive it. You can try to drive it through some kind of a large firm and see if you can seep through the bureaucratic processes in order to get things going. And generally speaking, I think innovation that starts from the top, even if it's done in private firms, looks a little bit like the Soviet Union, in which you get these sort of heavy management drives and bureaucratic imperatives trying to do things, and it doesn't mix very well with respect to the creative element. And so if you actually look at the pattern of innovation, I mean, it's not an accident that all the great firms of today started in somebody's garage many times ago, because it turns out that what you need in order to innovate is a kind of a level of freedom and space so that you could revise your business plan, revise your capital requirements, revise your objectives on very short notice. And as in all forms of evolution, there are many cases in which small things seem to have an enormous advantage over large things. And by and large, with respect to innovation, if you can start small and get yourself the flexibility, that is going to give you a huge advantage over trying to start large and figuring out how you create some kind of subculture within the big culture that can do this. Now, this has profound implications because the first thing that you have to do when you innovate is not worry about your IP. What you have to do is to worry about your financing in some form or another. How do you get this thing going? And generally speaking, if you wish to have this kind of informal type of arrangement, the financing that you're going to have to do is by and large going to be some kind of self-financing with respect to the business. So people will max out on their credit cards. They'll take loans from their grandfather or their aunt or their uncle and put it into these things because these are the only individuals who are essentially willing to make bets with respect to people based upon personality and trust, because they have the implicit assumption if they don't get paid back, which is often going to be the case, what happens is we'll just treat it as a gift and we'll go on, because that's the way in which close families and various other kinds of associations start to work with one another. And so what you do is you immediately have this sort of slightly chaotic form, and the business model often agrees with that as well. And so it's not as though people form explicit partnerships at this particular stage or even have an exact awareness of what the division of the take is going to be amongst them, which could be the source of problems later on. But what it is a kind of loose pooling amongst a select group of individuals in which out of this particular soup you hope you will come up with something, or many times something in the form that could be protected by intellectual property, and go forward with the kind of venture that you're trying to deal with. Now, at this particular point, the question is then what kind of contract do you start to need when you're trying to put these people together, and how does this thing start to work? And the answer, I think, in many of these cases is you need what the Romans used to call, bona fide contracts. And what they meant by that was these are arrangements which everybody does in accordance with everybody else, what the general principles of good faith require. Now, this term seems to be an open invitation for disaster given the looseness of the phrase, but in effect the notion was actually quite rigorous once you got to the bottom of it. And the theory of a good faith contract is that we have a miniature Marxist society hanging out there. What we expect of everybody under these circumstances is to contribute to the maximum of their ability and to take out only their kinds of proportionate gains. And so every time you make a decision, you're supposed to worry not only about your own interests, but worry about the interests of everybody else and treat their benefits and their harms exactly as though you would treat your own. Trying to do this in a large-scale organization with a bunch of anonymous strangers is an open opportunity for failure. But given the fact that the secret of small organizations is that you get to choose your partners, and you do so on basis of trust and affinity and so forth, means that the assumptions are much more likely to hold true in this kind of environment than any other. The advantage that you get by stating the obligations between individuals not as fixed rules, but rather as stating them as kind of loose standards, is in effect the enormous amount of flexibility that it takes every time there's an unanticipated bump in the road. You can start to have some kind of reorganization without having to have lawyers draft the 14th Amendment to the 13th corporate agreement that you put into place. So that the initial stage of these things turns out to be from the outside quite chaotic, but from the inside you hope it turns out to be highly cohesive. And then the question is, as you start to move out from this particular phase, what happens next? And what this particular point is, the usual stage in the cycle is that when you have capital requirements that are greater than those which you could get by the sources that I mentioned, what you start to go is the specialists of lending of one kind or another, venture capitalists of various forms. And at this particular point, IP now starts to have a more important role than it does everywhere else. And so if you go back and you read Peter Thiel's recent book when he talks about competition for losers or for suckers and so forth, well, Peter doesn't really mean that, but as a good salesman who's made the odd buck here or there during the course of his career, he knows the importance of a catchy title in trying to work an organization. And essentially what happens is if you're one of these big, fat, mature organizations that I've talked about, the price that you pay for the enormous stability that you have is, generally speaking, you can earn a competitive rate of return on your capital, which is nice if it turns out you're a widow or an orphan, but it's not so nice if it turns out that you're an entrepreneur. And so the basic Thiel motive in all of these cases is if you're starting out from this, primordial goo one way or another, what you're trying to do is to develop in a particular space, given your knowledge of the field at large, in an area in which you can attract super competitive returns for the kinds of work that you're trying to do. And the way in which you now try to do this is to attract venture capitalists who will fund you on the hope that they will be able to share in this. But now the relationships become a good deal more formal than they were at the earlier stage. These guys are now going to transform the way in which the business is done in at least two directions. One of these things is they're actually going to start to figure out whether or not you've got some intellectual property. Now, why does the intellectual property matter? Because at this particular point, you're hoping that the intellectual property that you have is not merely an exclusive right to do this, that, or the other thing, but actually confers upon you some genuine monopoly power. My friend Stan started to talking about how copyrights and property are sort of the same thing in many ways, that many forms of exclusive rights are no more monopolies than the ownership of your car or your home. Well, it turns out if that's the kind of intellectual property you have, you can kiss your venture capitalist friends goodbye. They have no interest in you any more than they have interest in funding your house or your car. And so what happens is you have to understand that all intellectual property is not built alike, and that yours has to be a little bit more muscular in the way in which it puts things together. And that muscularity means that you have to be distinctive enough so that you have, in fact, at least a short-term prospect for super competitive returns, which will get these guys to give you money on a higher level. And so at this particular point, you now have to start to demonstrate the kinds of property you have and to show its patentability and so forth. And now the certainty associated with the legal system certainly comes into play. If it turns out that you have something which you think to be a new invention of one sort or another, and you're running off a patent system which takes forever to prove this particular thing, and it's going to be capricious in the way in which things are valued, one of the things that you will not be able to do at the venture capital stage is to take this ersatz piece of intellectual property and use it as a basis for future financing, simply because the indefiniteness of the rights will scare away all potential lenders. And so what happens is now the traditional view that property rights should be known unknown and certain becomes extraordinarily important with the cycle, because what it does is it doesn't allow you in the first instance to vend to customers, which is what many people think about. What it does is it allows you to sell it, to lend it, to cooperate with venture capitalists, because they now can evaluate not only what the worth of the invention is or the writing is in terms of its intrinsic properties, but they can also figure out the strength of the exclusivity in question. In dealing with this, I think the problem is much more acute on the patent side than it is on the copyright side, because generally speaking, distinctiveness in copyright is not the real issue, whereas when you're starting to talk about patents, prior arts, and all the other complications turn out to be, I think, a much more serious kinds of problems. But the definite nature of the rights becomes important, not only in the marketing stage when you have the thing finished, it also becomes relevant in the production stage when you're trying to get that first level of financing. And the second thing that one happens in these particular stages is all of a sudden your mode of organization has to shift. It is not going to work for an outsider to simply allow you to have good faith chaotic arrangements that work in small number type situations. What you have to do is to find out ways, as the dollars become more serious and the number of players become larger, as the effective relationships become weaker and the financial relationships become stronger, you must be able to develop a system in which these guys can monitor what it is that they're getting and how they're going to move. Now, there are two strategies that they can do. One of these strategies is the venture guys can come in and say, you know, we're going to become part owners in this particular situation. And if they then start to take this thing over, they face the very difficult problem that two cultures, one from the chaotic garage and the other from the rich venture capital firm, will clash in the way in which these inventions run. And so generally speaking, the smarter way to do this is to organize the transaction in which the creative control remains with the initial group, but now they have to meet various kinds of milestones that are set underneath the consensual arrangement to prove that they're making progress in a particular way. And it turns out, I think, that the venture capital business is now largely organized along exactly those kinds of lines, in which what happens is you guys figure out what it is that you want to do, but this is what you have to achieve by January 1st of next year, this by June 1st, and so forth. And essentially what happens is you specialize in output contracts. You figure out what it is that you're going to do in order to get there, but we have to have some observable that we can measure to decide whether or not we want to keep this arrangement alive, pull our funding, take over the business, and so forth. So that the strategy of campaigning and contracting is really quite different. These are not standardized contracts in the sense that you can pull off the shop and do it. They have to have timetables, they have to have technical specifications built into them, which can only be negotiated by knowledgeable parties, which often means now that the culture that existed within the firm has to change a little bit, because these guys who are creative geniuses may not be so good. They have to hire lawyers and other kinds of people to start to represent them, and slowly the nature of this particular business is going to change, and change very radically. Now, when you start to put these things together, then the question is exactly how do you put them together? And at this particular point, it's not only the property rights that matter, it's also the freedom of contract doctrines that matter, and matter a great deal. There is no question in dealing with these kinds of situations that the peculiarities of the particular situation are such that there is no standard form arrangement imposed from without which should be able to dictate what happens within a particular firm. And so how does the process work, and why does it make sense? Well, the first thing you do whenever you want to be novel is to try to be imitative. And what I mean by that is you're putting together one of these standard venture capital deals, and the first thing you do is to ask yourself, what can I learn from previous deals, the public terms and agreements of which may be available to me, and use that as a base point from which I can then start my own particular arrangement. And this is used in virtually every kind of business. And then the second thing you do is, when you take this particular kind of form, is you look at it and say, where do I have to alter it? What changes do I have to make so that I can develop my particular line of the business in a way that makes perfectly good sense? And that sort of individual tailoring requires a common knowledge of both the technology on the one hand, the customary terms of the industry on the other hand, and also what it does is it requires that you have a very acute awareness of the question of whether or not opportunism is going to start to arise in the game. Now, when you're dealing with these small, intimate little associations at the first stage of creativity and development, what typically happens is the opportunism issue is not going to be nearly as large as it is in the other cases, because you get direct observation amongst friends, so that you have higher monitoring on the one hand and a smaller incentive to cheat on the other. But as you start to increase the size of the business, not only are the milestones going to be important, but you're going to have to start worrying about inspections and reviews of books and financial statements and all the rest of the stuff in order to keep this thing alive. And so what you then do is you try to succeed in this kind of an arrangement. And then the next question is, how do you start getting products out to market? And now the problem with the closed corporation is, again, a different kind of an arrangement. And let me see if I could explain to you what I think the problem is. If you start with the traditional first two stages of this, generally speaking, you're talking about bilateral arrangements or relationships amongst a small number of persons. The moment you start talking beyond the development stage and start talking about the sale and marketing chain, you have to start thinking about distribution chains, supply chain management. You have to do it on both the input side, what you buy and how you get your equipment. You have to do it on the output side. Do you use salesmen? Do you sort of contract out to other businesses? Do you create your own retail outlets? Do you share with somebody else? And so forth. And these are also very different contractual differences from the ones that have otherwise been had. And the problem with this situation is, when you're talking about two-people contracts, generally speaking, it's all right to say, you know, if it doesn't work out, we'll just take the business back, or we'll take some kind of financial penalty. When you start talking about long and complicated distribution chains, either on the supply side or on the distribution side, none of this works. So let me explain to you how, in terms of contractual doctrine amongst the lawyers, things have to change in order to make sure that you get your expectations in the proper form. One of the most insidious doctrines that exists as a matter of contract theory is the so-called theory of efficient breach. And the term efficient breach is to some extent an oxymoron, because breach is supposed to express the notion of some kind of a moral wrong, and efficient is supposed to express the view that what you've done is something at the highest level of social welfare maximization. And it can't sort of be that that is the case. But at least in two-party arrangements, what you can say is this: it may be wrong for somebody to breach a contract, but if damages are available, by and large, they will generally be able to put you in at least a respectable position. But the moment you start having supply chains and more complicated, what happens is you cannot treat contracts that are formed as being in isolation with one another. You have to treat the contracts as being formed as being part of an elaborate distribution system. And what happens is, if there's non-performance at any one stage in this situation, it will break to some extent the chain, and it will have collateral consequences downstream. And to try to figure out what expectation damages are under circumstances where first one party has to figure out what its losses are because it can't meet another contract, and then the second guy trying to figure out whether the failure of the first guy to supply him is excused because of frustration because he couldn't get his stuff from somebody else, and then you go on down the chain and you keep radiating out, means that any single rupture results in 1,000 situations in which the performances are basically knocked offline. And so when you're starting to deal about creative industries of any sort, and I think this is true on both the copyright side and on the patent side of the type situation, what you do is you stop shifting your emphasis from figuring out remedies in the event of breach, and you try to put into a system a system which simply tolerates no breaches at all. And what you do, in effect, is specific performance as a remedy, as an ideal, becomes much more important when the supply chains become longer than it does when you look at any particular contract in isolation. And so what is it that you do? Well, there are both private and public issues that have to be taken into account in order to be able to organize this system into a coherent way. And in the private system, the question is how you start to organize these arrangements. And it turns out there's some very profound choices that you have to make. One of them is to say, look, the really smart thing to do is to basically enter into long-term contracts with single individuals, pick them with a great deal of reliability, and make sure that you've got gilt-edged stuff going all the way up and down the line. And at this particular point, your monitoring tasks are going to be effectively reduced in virtue of the fact that there are fewer people whom you have to monitor. And then what you do is you take everybody that you hire and make sure that they monitor everybody that they hire. And so that what you do is you have a high degree of reliability at each particular stage, and you can make this thing go, avoiding the holdout and opportunism problems by having specified long-term contracts. The difficulty, of course, with that particular strategy is it might work 99% of the times, but in the 1% times that it doesn't work, it could be a catastrophic loss, because if there's a break in this particular change, there's no substitutes that you have for it, and the nightmare scenario of all these agreements simultaneously unraveling starts to take place. So what people then start to do is to say, you know, we really have to build an insurance. And so what we have to have is 2 or more people at certain critical nodes so that one can pick up the slack where other people leave off. Increasing the number, of course, then gives you this kind of an insurance function, which is altogether a good thing. But on the other hand, it also has other problems. One of the things that we've talked about before is that when you're working complicated chains on supply and on distribution and so forth, there are often know-how or various kinds of trade secrets that you've developed in your business. And as you expand the number of people with whom you deal on either side of the line, it may well be that you have to share the information that you have with a larger number of individuals, and that creates the danger of a rupture from another source, because what you can say about all sorts of trade secret information is once this thing gets out into the public, at large, there is no way that you could call it back. And even worse, as most people who work in trade secrets know, is that the biggest fear that you have is that somebody will steal your trade secret and you will never find out that the thing has been stolen, because what they will do is not advertise the trade secret to the rest of the world, at which point they turn a duopoly into a competitive return. What they will do is they will keep secret the fact that they've stolen something from you in the way in which it works, so that you might not even be able to figure out what's going on. And if you can't figure out what's going on, you can't remedy it. So what you're constantly dealing with is making a kind of a trade-off between worrying about rupture, which requires that you have some degree of duplication, and then worrying about leakage or of information or management oversight and quality control, which gets when you diversification. I think it's fair to say that the more complicated the organization, the more unwilling you are to rely on single linear chains, and so the supply chain management issue becomes something which in effect now looks more like a network, as there are multiple nodes in multiple places as you start going down the system in which you can do this. Now, in order to make this thing work, it also depends upon what the terms of the agreements are. And at this particular point, it becomes extremely important that you have freedom of contract on these issues, because otherwise you will never be able to make things work in the pattern in which you would like them to do. So that one of the things that we know is that if you're working these arrangements, you will have to be able to tell whether or not somebody is or is not in conformity with what it is that you've required. And generally speaking, the more complicated the chain, the more it is that you demand output measures be satisfied rather than input measures be satisfied. And the more it is that everything that is relevant to the contract has to be subject to inspection at the time that a particular thing has been done. So if you're trying to figure out where regulation, in fact, can really mess up one of these distributional chains, all you have to do is to say, well, when you take something in from overseas as part of your distributional chains, you have to be perfectly sure that it's been made only with labor which is treated in the proper fashion. And the reason why this is so dangerous is not because we're in favor of exploitation of child labor or whatever it is that there's no way within the supply chain framework that you can actually examine these kinds of things. And the moment you have to go outside of the supply chain in order to check this stuff, a large portion of the efficiencies that you have are not there. So the thing to state about this is if you start with intellectual property and you then start to commercialize it, one of the things that will affect the commercialization of the intellectual property is the ordinary law of having to deal with the sale of goods and merchandise and so forth, because the stuff that you're selling, in effect, having created the intellectual property, is in fact now governed by a very different body of law. It may be the ordinary law of contract, the Uniform Commercial Code, the International Sales Code of one form or another. And so that what happens is, if you're an intellectual property expert and you're trying to figure out how these things start to work, you are now faced with the fact that you have to deal in somebody else's turf the moment it turns out that you now are engaged in the axis of commercialization. So you can't be concerned just with the IP development stage of the situation. You have to be concerned with everything else that's going to take place either before or after, which will be governed by other areas of law, many of which will be even more interventionist in terms of government regulation and control that they are in this particular area. Think of trade secrets, covenants not to compete, a whole variety of issues in which it turns out, like in employment law, there's a very heavy hand of government regulation, which when it feeds back into this particular situation can create a lot of difficulties. Now, so far what I've done is I've talked about this as though you're talking about chains, but again, of course, the business is much more complicated than that because there's always the question of exactly what form of vertical integration do you want to take place. And at this particular point, the stuff that we talked about earlier on, the kind of culture issues, actually come back and assert themselves. In the initial iteration on this discussion, I talked about culture in connection with those particular cases where you get these loosey-goosey creators dealing with the venture capitalist types and trying to figure out what's going on. It's quite clear when you think about more advanced stages, the distribution chains will often have people who are creators, i.e. copyright types, and innovators, i.e. patent types. And in many cases, the two industries really work under very different kinds of operations and systems. So if you're trying to figure out what a creative guy is, the first thing you have to do is to take off your tie, because everybody knows that a tie constricts the blood flow to the brain. And secondly, what happens is you have to start making a very strong appreciation of the subjective nuances of a particular thing. And my son turns out to be in the entertainment business, and if you're all interested in teenage girl shows, I hope you will watch Happy Land, which is his new show coming out. That's the family plug. And I actually went to the studio and watched this being made for an hour or so. And I said, I could survive in this environment for about 10 minutes. I mean, I had no idea of the way in which these people interacted, what they did, but they seemed to know perfectly well what they were doing, and they looked at this sort of odd law professor who basically regards human relationships as asking his assistant to help him change the typewriter change the toner inside his printer. I really am old, aren't I? Change the toner inside the printer so I could go back hacking something out on a screen. But there's no cooperative function associated with academic production. And in the entertainment business, I can't tell you the number of layers and modules and groups that start to come together. And the only reason they work is they have a kind of a common culture associated with them, notwithstanding the differences in the trade. Well, if it now turns out that you're in another kind of business, which is the production sort of business and the distribution business, it may well be that you have a rather different mantra, which is, I don't care how complicated the problem is, unless you can reduce it to a series of zeros and ones which are capable of binomial expansion, you do not know what it is that you're talking about. And so these guys essentially carry chess to the nth degree because they don't ask about anything in terms of abstractions or subjective preferences. They say, give me a specific piece of code which will solve a particular piece of problem. If you can do that, you're my friend. If you can't do that, please go out and do something else. And the question that you then have to ask is, can you merge these two kinds of individuals into a single firm or not? And the problem of vertical integration is, in fact, extremely important. And it goes back to fundamental work that Ronald Coase, my dear and departed friend, did back when he was a young man in 1937 on an article called The Nature of the Firm. And it turns out that the complicated cultures that exist with respect to the production and innovation industries often give rise to sort of serious difficulties as to how it is that you put these things together. And what Ronald did was to ask very simply, why are there firms? He said, look, we all talk about competition, and competition talks about a widget, and the widget has a distinct price. So why is not every form of interaction that takes place simply an interaction that takes place between a buyer and seller at a particular price of a widget in question? And what Ronald came up with was a very profound insight that it takes, as it were, a complicated market to figure out how you structure these transactions. The valuation is not easy, and sometimes the transactions cost of trying to do things in an arm's length relationship through a system of sales are more costly than doing it through an informal network of arrangement, which is why it is, of course, that all venture capital firms have these sort of informal associations of the primitive nature of a firm. All right, well, once you understand that there is this constant trade-off between external relations with precise contracts and then these informal relationships with fuzzier deals, the question is, what do you do when you start having different kinds of cultures? And there are two ways in which you can do this, roughly speaking, and they each have advantages so that you'll never be able to come up with a dominant solution. In one case, what you do is you find somebody who is an extremely gifted person, you call this person a manager, and what the manager does with respect to the firm is essentially to ease all the tensions that would otherwise take place between people whose cultural instincts and intellectual styles are somewhat different from one another. And generally speaking, I think it's fair to say in any firm that the higher you go in the organization, the less your knowledge of anything in particular about what the firm does matter. What really matters is how good you are at having the antenna that can read, as it were, the personal sentiments of the various kinds of difficult and creative people that you have to work with and organize them in ways that make them happy to deal with one another. So essentially what you are is the mediator between factions that might otherwise go to war with one another or simply disappear. Now, it's very difficult to be a full-time employee with that kind of strategy, and sometimes it simply doesn't make any sense to do so. So roughly speaking, if it turns out that the amounts of inputs that you need from one side of this thing, say from the innovator side, is smaller or more erratic than the amount that you need from the copyright side, or the other way around, trying to put them all in a single firm is going to be very bad, because the mismatched proportions means that somebody is going to be working overdrive on the one hand to be underemployed on the other hand, so there's a lot of redundancy or wasted production. And at that particular point, what you do is you now take your intermediate, and instead of having this person as an employer or as a manager, what you do is you have him as an agent or a broker. And what he does in effect is he forms, loosely speaking, certainly in the entertainment business this seems to be the case, they're loose stables of people. So I know 6 cameramen and 5 editors and so forth. And when I have a particular product, I go to my favorite list and I see which of these characters are available. And what I do is I manage to organize the team at one level. And if it turns out that we have to do this not only with respect to creative people, but also with technical people, I can get you a list of people who can do those things as well. And what happens is you have to incur the transactions cost of putting this thing together on a unique basis, but the advantage is you actually get a framework that seems to work for this particular deal. And then when it's done, the deal starts to dissolve, the firm is over, quote unquote, and you go back into this state. And I remember when my son went to the Tisch school, the first day I sit in the audience and the guys in front are telling us what it's going to be like. And they said, look to the left of you, look to the right of you. They didn't mean that one of you will be out of the business next year. What they meant is, you know, guys and dolls, you'll be hiring and firing each other for the rest of your professional careers. And as best I can tell, that's exactly the way in which that business works. That is, this is a business in which there are large numbers of small firms that sort of operate, and then other firms that operate in the opposite direction. Now, the question is, once you know this, one of the reasons why freedom of contract is so important, and one of the reasons why you don't want to have various kinds of regulatory obstacles on labor contracts on the one hand or corporate formation on the other, is that if in fact these choices are as sensitive as they are, there's going to be nobody from the outside who's going to have greater knowledge than anybody from the inside as to what the particular mode of formation ought to be. Now the question then is, and I have what, about 5 minutes left or something like that, that is, what does this then again tell us about the legal framework and the various issues that we have to deal with? And essentially I want to just pick up a leaf from what Eric Clay said this morning about the importance of the various kinds of arrangements that you need in order to make this kind of system go, given the infinite variety of what you have. And basically what happens is all the law consists of only 2 kinds of arrangements. There are those that are voluntary and there are those that are coercive. And what has to happen in order for firms to work is that you have to make sure that the incentive structure is such that the voluntary arrangements will dominate over the coerced arrangements, which are essentially barbaric arrangements imposed by the outside, people who don't know what they're talking about in a particular thing, saying that you can or cannot do this type of an arrangement. So what's the first thing that you need? When you start to think about this as a complicated set of chains, what you really need is to have very strong remedial protections so that nobody can deviate from the previous agreement. No outsider can horn their way in on the established arrangements that parties to a transaction have, and that translates itself to injunctive relief. Or what happens is that when the courts start looking at this thing, what they do is they tend to take the pathological case in which they assume that there's a massive holdup by one person of another person, and therefore say that injunctive relief cannot be done and we remit you to damages. What happens is when you take that out of the 2-party context into the N-party context, is it means that the unraveling problem that I talked about before is essentially one that's going to be extremely difficult to stop if it turns out that people can go away, do whatever it is that they want, and you have to come after them after the fact in order to see what kinds of damage awards that you're going to get. So the important thing to understand about an injunction is not the way it either works or misfires in the cases that are actually under litigation. The key feature about the injunction is that if it is in place as a general remedy, the need for its occurrence and use will be much lower than might have otherwise have been the case. And that what will happen is that people know that they can't profit by engaging in this kind of conduct. They will keep within their supply chains. They will keep to their obligations. They will work things out by informal accommodations, and they will not constantly put themselves into a position where they're going to threaten it. So over and over again, when I start speaking to people about what their business is, they are frightened to the death, particularly with patents where the information is public, that somebody will use the patented commodity and then say, come sue me. Because they know that even if the lawsuit wins, it's likely to be settled, very expensive, uncertain to calculate the damages in question, and all the rest of it. Now, what does this then tell us about remedy damages? Well, the single most dangerous thing in the law of damages is, in fact, the standard form of damage argumentation, which is given forward by Lon Fuller and a man named Perdue, who was his student, and when he started to talk in the 1930s about the reliance interest in the law of contract. And what Fuller did, he was an Aristotelian. And that's just fine if what you're trying to do is to read Aristotle. It's not so good if what you're trying to do is to organize commercial arrangements. So he came up with a topology of contract remedies, which essentially were expectation damages, put you back in the same position that you would have been in if the thing had been performed. And he was just talking about simple contracts at sale and not these complicated networks. Or reliance industries said, we can't give you your profits, but we'll put you back so you didn't lose anything. And then restitution, where you get back from somebody else that which he has conveyed unto you. It turns out if you look at any sophisticated commercial agreement dealing with the problems of consequential damages and so forth, the only thing that you do not see in these agreements are either an expectation measure, a reliance measure, or a restitution measure. What they realize is they have very different kinds of requirements in different contexts, and they try to create a damage regime which reduces the probability of breach and reduces the damage once the breach starts to take place. So that when you're dealing with supply chains and you understand how serious these things are, the last thing you want to do by way of modern patent reform, and remember patent reform is right in the air now in Washington, D.C., is to say we're going to give you your expectation measure of damages. Because what that means is that the guy who steals knows that he's going to be no worse with theft than he is going to be with compliance. And the key thing to understand about a high damage situation under these circumstances is that it's designed to reduce the probability of breach ex ante rather than to give you the ideal remedy for breach ex post. And when you understand the strategic institutional structure of these remedies, then you don't worry so much about quote-unquote justice in the individual case. You worry about the long-term stability of these arrangements. So that what happens is you now, in order to make the chains coherent on the production side, and remember, vertical integration in the firm is often very costly, you have to have good damage and good injunctive reliefs. The second thing you have to do is to have freedom of contract with respect to the way in which the licensing agreements are put together. And this itself is also something which is extremely complicated. There is, in fact, two traditions associated with how it is that we think about these private licensing arrangements in businesses. And one of them starts to come from ostensibly the copyright and the patent law itself, in which you have such things known as the first sale doctrine, which say it's only the original party to whom you sell the good against whom you can have some kind of protection, but you can't require that party to put further protection in down the chain. And the first question you have to ask yourself is like, why? And if you start looking at the standard literature, for example, in the LG versus Quanta case, what they do is they resort to the kind of mumbo-jumbo that one heard of in connection with standard rules on property, estates, and land. What they say somehow or other in the land case is that putting a restraint on alienation is repugnant to the nature of the fee, and nobody knows exactly what that means. And they do that exactly in this context with IP, saying that somehow or other putting the restraint on a subsequent taker is inconsistent with the inherent nature of a property right under either patent or copyright law. And so that what happened is the remedial structure does not allow you to reach downstream parties. It turns out in some particular cases, these licensing arrangements are enormously complicated. And in fact, the reason they had a complicated arrangement in the LG case was that some of the people who were going to take the products from Intel, who was the intermediate in that case, already had licenses from LG, so they didn't have to license it again. Other people did not. And so a notice function which said, if you don't have a license, please take one, is in fact exactly the sensible way to go in order to avoid double payment by those people who are your long-term licensees. And when the court says we can't do it in this particular fashion unanimously, what they're doing is they're making it much more difficult to contract up and down chains by insisting that privity is in fact not only a legal construct, but a binding constraint on the way in which the deals turn out to be done. So what's the right thing to do? The right thing to do with intellectual property is the same thing to do everywhere else. When you look at all of these cases, you're always worried about the use of intellectual property will not only create monopolies, some of which are good and some of which are bad, but they'll also create cartels across rival producers. And so in each and every case when you start to see one of these restrictions, one of the questions you should ask, is there absolutely a tendency towards monopoly or concentration that would be actionable under the antitrust law? By the way, when I say antitrust laws, I mean antitrust laws as I would construe them. I don't necessarily mean antitrust law the way in which certain other people in Washington will construe them, although I would think the antitrust law has been less beaten up in last years than many other bodies of law that we've happened to face. And so you run it through an antitrust filter. And indeed, that's exactly what one did with the patent and the copyright system before we had these modern innovations. We may have gotten the wrong antitrust laws. I think we often did. That is, there was much too much suspicion of various kinds of vertical restrictions, tie-in arrangements, exclusivity deals, and so forth, most of which have some pretty good efficiency explanations. But if, in fact, you do it that way, what happens is it gets back to the theme that I started the lecture with and which I'm now going to end it on. As I said in the beginning, one of the great things about doing old-fashioned contract and property law was to speak about A and B and about Blackacre and Whiteacre, because what it did, in effect, is it forced you to get some kind of a generalization about the way in which you approach subject. Now that we have intellectual property, either in the form of copyrights or in patents, and we are now seeing these kind of complicated arrangements go, what we're saying is the basic rule is freedom of contract. Let these people roll their things the way in which they see fit. If there are customary standards and silences in the contract, we apply the custom. But in all cases, we're always worried about whether or not you're going to operate these systems with respect to restraints of trade. And we now have an antitrust stuff which says we know what the danger is of horizontal concentration. We're going to stop it. And so if two patentees want to get together with substitute patents, we're very suspicious of allowing them to do so if, in fact, we think it causes a cartel. On the other hand, if it turns out you're trying to get a bunch of people together in order to put together an industry-specific patent under a FRAN type of an arrangement, you don't want to subject that to the antitrust laws, because that makes it impossible for people to get complements together, which will reduce the transactions cost both amongst the members of the patent pool and allow them to present a uniform face to the rest of the world, so that when they engage in their licensing activities, they can do so at much lower cost and much greater reliability than if you're trying to sell off these pieces one after another. And so the lesson I think that one has is, if you look at this full system, it's the basic sense of property and contract law that unite the competitors on the one hand in the creative industries and in the technological industries. And if we stop trying to be overly specific about what we do and think about this in a more general form, in general, you will get better results than if you start to go with the kind of endless ad hocery, which seems to affect legislation, particularly at the federal level, more and more as we go forward. My favorite anecdote on this is when they put together the 1952 Act, they had two people who drafted the statute, Federico and Giles Rich. It passed by voice vote in both the Senate and the House. And they did a much better job than the clowns who put the things together in 2011, proving you, I think, which is an important situation, is that the amount of devotion that is given politically to the legislative process is inversely proportional to the gains that we get, because ad hocery is the nature of the game in 2011. Generality was the nature of the game in 1952, and we can now see the relative differences in the outputs as reflective of different kinds of philosophies. Thank you. Can I take questions?
Richard, yes, Richard has very kindly agreed to take questions from the audience, if anyone has any. You also got a short taste of what I experienced repeatedly as a student, where I would ask a question, he would spend 10 minutes explaining to me why I was wrong, and then another 30 minutes explaining why the ways in which actually I should be approaching it and thinking about it from that perspective. So.
Let me salvage something of what you said. Questions? Come on, you can't all be that shy.
Well, I will lead off with a question.
You always do.
Yes.
Give me the mic.
So I want to push back a little bit on your starting position that we had framed it improperly, because you actually came back and acknowledged that we had framed it properly, because
Give a man literary license.
if I could summarize your remarks, and if I'm doing this correctly, that the way in which intellectual property in both copyrights, patents, and as well as trade secrets and trademarks function is that it provides a scalable platform from which you can move from different commercial arrangements, providing stability and certainty through rule of law mechanisms and through the various doctrines that permit freedom of contract and the types of internalization of externalities that you have with the corporate.
Amen. Keep going.
So, on those terms, I'd like to then address. So I understood your talk correctly.
Mm-hmm.
So then I'd like to ask you about your views on, which you touched on briefly toward the end, with respect to the deployment of antitrust today in the innovation industries. We see a lot of talk in Washington D.C. among regulatory agencies and at the FTC, the DOJ, and others about standard essential patents, about patent pools, and other types of private ordering arrangements that we've seen in the market with respect to patent and innovation. And could you just comment on that a little bit more and expand on some of your short remarks at the end?
Yes,
of the talk?
I mean, look, I think it basically, my rhetorical excesses at the beginning were designed to alert people to the fact that there's a general theory behind all of this. It was not designed to say that your substantive points of the views, which have been formed by wonderful instruction when you were a student at the University of Chicago, are in some deep sense fundamentally flawed. And if you remember the word that I said when I started to talk about the antitrust laws, I said, as the antitrust laws as I construe it. I said not as it's construed elsewhere and in Washington. And essentially the difference between these two views is as follows, and I think it's extremely important. If you go back to sort of neoclassical theory, and you're trying to figure out what are the really profound results on sort of industrial organization, I think there are two. If, in fact, there's a horizontal arrangement between strangers, you can put together a nice little diagram which starts to show how you take a competitive industry, reduce the output, increase the producer surplus, reduce the consumer surplus, where you're perfectly confident that the loss in the consumer surplus is greater than the gain in the producer surplus. So generally speaking, you're not going to like this. To libertarians, there is then a split in the way in which they think about this. There are those libertarians and all the sort of consequentialist economists like myself who say the last thing the government ought to do, therefore, is to prop up and to support these kinds of cartels and to make things that might fade away into some permanent arrangements. And with that statement, essentially what you do is you indict the entire progressive era from soup to nuts, because its expertise in field after field is to take perfectly competitive industries and to turn them into cartel and monopoly type arrangements, and to give them a political durability which makes them much more dangerous than they would have been if they had done this on their own device. And I think the Agricultural Adjustments Act, the Motor Vehicle Act, the Civil Aeronautics Board, National Labor Relations Act, there's a long line of stuff which essentially is, in fact, using the antitrust law in the opposite direction. That is, we don't care about the antitrust law, so we organize it. And I keep on reminding people that, as a general matter, perhaps the single most dangerous feature of the Wilson period on antitrust was the categorical exemption of agricultural arrangements and labor arrangements from the antitrust laws, which took place in the Clayton Act of 1914, which is, of course, in the early Wilson years. The hard question is, do we allow these cartel arrangements to exist and then simply to fade away if it turns out that they're not efficient? And there's a big, difficult battle over that. And let me just see if I can point out some of the reasons why it's sort of ambiguous. The first thing is that you discover it is not correct to simply assume about a cartel that it has no efficiency properties associated with its operation. in principle, if in fact you allow people to coordinate, not only can they engage in restrictive practices, but they could also engage arguably in strategies which will reduce their joint costs of production. So to some extent, the monopoly element will start to be offset by the efficiency gain. In general, I think it's the case. These things are less pronounced with cartels than they are with respect to mergers, where in fact the fundamental nature of reorganization can promise some real efficiency gains. And indeed, one of the reasons why you know that is sometimes when a merger is allowed between two firms, what you discover is that the price of competitive firms goes down, which suggests that there's an efficiency, whereas if this were a restrictive trade practice, the price of the smaller firms laboring under the cartel umbrella would start to go up, because that meant, in effect, they know that the dominant guy is going to reduce output and raise prices. That gives them more price and quantity freedom than they would otherwise have. And that's a long and difficult kind of debate to start to take over. And in general, I think that a kind of a modest and circumvent view with respect to cartel formation is probably the enforcement's pretty good. Mergers, it has to be ad hoc. Vertical arrangements is a very different proposition. And one of the things that you ask people is what happens if you go from 2 to 10 horizontally and 2 to 10 vertically in a chain of production? Well, if you go horizontally, you're increasing market power, you're reducing the probability of any efficiency gains over those things, and the case for enforcement gets quite strong. When you go vertically, essentially what you're talking about is one of these vertical integration chains. And what you realize at this point, cooperative arrangements between the parties are absolutely vital for keeping things going because of what is known in the business as the double marginalization problem. And essentially, if you start having sequential production and each of these guys turns out to be a life unto his own and can set whatever price and terms and conditions you want, you get something like a common pool problem. I only worry about the gains that I get from a price restrictions, not to the loss of everybody else in the system. 9 other people are doing the same thing, and you could take a fairly series of nice diagrams and show how substantial gains from vertical cooperation are essentially destroyed by this. The Treaty of Westphalia, recently decided in 1648, essentially opened up the Rhine River, knocking down all the toll gates that existed by individual fiefdoms, and the amount of gain for the system was just enormous. So the real point is, if in fact you're talking vertical, government intervention, which essentially starts to tell you about the way in which you put these chains together, is likely just to increase the double marginalization problem and create all sorts of difficulties, and you have to run from this. So generally speaking, if you listen to a government official, and they're talking about their cartel program, you sit there and you say, maybe you've gone a little bit too much, maybe not enough. But when they start talking about, we're going to give really tough scrutiny with respect to these vertical arrangements, it's at that point you start to cringe. And the reason you do this is something else. A cartel today is secret, and they have to basically figure out how to do it. There is no way that you could run a complicated vertical supply chain and not have public documents which tell you exactly what you're doing. So whenever you're dealing with vertical integration cases, either here in the economic union over there, and those guys are hopeless on these issues, everything is just tied on the legal implications from admitted facts. And so at that particular point, the legal theory becomes much more important, and the view that somehow or other there is some hidden efficiency loss through the restrictions is crazy, because we could identify the enormous efficiency gains that come by stopping all of these toll gates from taking place. So when you go to Washington, what you have to do is to tell them the antitrust law is as capable of abuse as any other system, and you have to have a very strong theory to explain to you what you're doing and why you're doing it. And the moment you have a theory, what it does is it now tries to constrain what official discretion would otherwise be. And one of the reasons why you have to be really suspicious of those people who say it's really so important that we have to leave it to the legislature because nobody understands it, what they're really saying is these guys understand it perfectly, but given their incentives, they will do very perverse behaviors. And that's what you have to try to stop. So in the IP business, you really do need government assistance in order to keep the injunctive relief and the damage system alive, but you have to be very fearful of government assistance in a whole variety of other kinds of areas. And so only a theory will explain to you where you want their intervention and where you do not. So that was my short answer. Somebody else a question, please? What a bunch.
No brave souls.
Oh, come on. Yeah, good. Brave soul. Oh, David. Oh, you again.
What about correctly songwriters.
All right, well, tell me the question.
What? Well, what are your feelings? I'm giving you an opportunity here to just go. What are your feelings about the consent decree that governs ASCAP and BMI, the two different consent decrees that govern ASCAP and BMI?
Well, actually, the first question I would ask is exactly which terms are you objecting to, and the second observation I will make right off.
Setting the prices. Let's start with that one.
Okay, that's good. Of course, the serious difficulty is that you don't want to have two different consent decrees for two organizations. As I remember, the ASCAP situations from the late 30s and the BMIs from the early 50s. Is that right?
41 and
52 or something?
Yeah, something
all right,
like
close
that.
enough. And, there's very different sentiments on the antitrust law, and you don't do that. The question in these particular areas, this is the way in which I would do it. I think it's perfectly okay to use ASCAP as a monitoring device, and the way in which you would want to do it correctly, okay, I'll just give you the correct result and then you'll see why you're right, is that when you put these things together, there are two things that you have to worry about. You have to worry about pricing, and you also have to worry about amalgamation. And essentially, the reason you need to have an organization like ASCAP is to make sure that when people do play your songs on a public area, you do not have to sit with a microphone at your ready in order to monitor what's going on. This was much more difficult to do in 1941 and 1952 when you actually had to listen to the stations, right? Now this is basically a relatively trivial kind of problem because you could get these various devices that monitor all stations at all times, right? And they give you instantaneous knowledge of what's being played and to what kind of an audience. And essentially what happens is the more you get things clickable, the more accurately you can meter them, and the more accurately you can meter them, you can price them. Now this then ties in with your second point, and this is why I think that you're correct. What happens is in a world in which you cannot monitor what the price is going to be for any particular item, there is a tendency to sort of give a lump sum price for everybody and then allocate it crudely in accordance with the number of times that the plays take place or something else. The more you have the information, the more it becomes clear that the appropriate way to do this business is as follows. What happens is ASCAP now becomes a monitoring arrangement, and what each songwriter is allowed to do is to set his own price with respect to his own stuff, and so that when somebody decides to broadcast that, they have knowledge of what the terms are going to be, and the broadcast is going to be an acceptance of the contract at that point. This will immediately allow people to differentiate themselves in all sorts of ways and to allow basically price discrimination to take place in accordance with demand. So David, you may be a very ingenious guy and you'll say, this is my price schedule. I'm an electricity company. Peak load time, 3 o'clock in the afternoon, you pay X. If you want to get me 3 o'clock in the morning, I'll take 1/10 of X because I think the audiences are small. And then you'll say, if you can actually monitor the size of the audience on the other side as you can on the web but not on the radio, what you will then do is you will charge a uniform price, arguably, with respect to the customer, so much per click, per listener, pair. And then if you're really sophisticated, you say, no, I know that this 18 to 49 group is my audience. I'm going to charge so much for them and less for the others. And these night owls are all septuagenarians. I'm going to basically accept a lower rate from them because they don't generate as much income on the side. So all of these things essentially lead to the following proposition. And this is the compatibility issue that, in fact, Adam started to talk about. If, in fact, you're dealing with something like intellectual property in the song business or in the patent business and use, and you have very accurate ways to count the use and know who the parties are, there is no reason whatsoever to have a collective size set by any independent body. It can perform the monitoring issue at very low cost. At this point, you probably don't even need them to do that. You could probably have it done voluntarily. So you break what might be a collusive arrangement in favor of individual a la carte pricing. Now, let me give you another example of exactly how this thing gets confused. There is something today known as a medical matching system. Are you aware of this? And, if anybody, a law student who's getting a clerkship, you realize that there's this ridiculous situation that you don't know when, in fact, you're going to match with everybody else. And so there's this endless amount of situations where people are sitting in the antechambers of Judge X and they get an offer from Judge Y who says that the thing will explode in 30 minutes and you don't know whether to take the interview or not take it. It's just a complete mess. In the medical system, what they do is you do all your interviewing, And then what happens is you list your people in order of preference, and the hospitals list their people in order of preferences, and you take the high ones. So if I'm number one on your list and you're number one on our list, we both go out, and then I'm number two on another list. I just disappear from that list. Somebody else moves up, and you keep making matches off the top until you get the pair. Now, that's a perfectly sensible arrangement for pairing, but there's absolutely no reason whatsoever if you're going to have matching that you have to have uniform prices that the hospitals are prepared to pay. And so the correct way to do this is not only do we interview and take you the basic situation, we also give you a term sheet. And then you look at your term sheet, and you can't set that term sheet in collaboration with everybody else. And when you start putting your bids in, you take into a fact that this is Mass General, and you also take into a fact that these shysters are offering you only $5,000 less than some fly-by-night hospital, and then you decide whether or not the decline in cash is worth the advantage that you get on the other side. And you can introduce a collective sorting mechanism without having a situation in which you have a collective pricing mechanism. And so it's absolutely critical to figure out how you keep these institutional arrangements together in order to make sure that you're going to understand how these businesses work. And the difference between us is, I know nothing about the music business. Thank God. But I do know about pricing mechanisms. And what happens is, as far as I'm concerned, it doesn't matter whether it's a song or a job or a piece of software. There is no reason, once you have the metering system, to have collective prices. The basic theory of antitrust law is, in a very strong sense, product independent rather than product specific. And the ad hoc arrangements of many of these decrees, which may have made sense at the time they were settled, they're not durable over time, and they should be re-examined. So you should file a petition with the Justice Department to see if they could take the yoke off the pricing side. This will make an enormous difference, of course, in the way in which things go, because it will award really successful people much more accurately and much more rapidly than it otherwise will do, and it will prevent the cross-subsidies that now happen under the existing framework. Okay, any other question before we break? Somebody? One more question.
One quick, brief question.
There's no such thing as a brief answer, however.
What are your thoughts or opinions, pro or con or both, of the Alice Bank Corp decision?
The who?
Alice Bank Corp decision?
Well, you better tell me what it is.
Oh, the
What?
about
Tell me. Is this one about whether or not software ought to
yeah,
be
software
patentable?
patents, exactly.
I mean, look, my attitude is both pro and con on this particular situation. And let me, since I don't remember reading the decision, as we say, I'm a part-timer in this particular field. What happens is you just think back to the morning, and the man, of course, who is passionate about patents is the man from pharma. And that's true at every one of these sessions, because they have very few patents and they're very big. And essentially, either you protect the big patents or there's nothing left. There is no software patent I'm aware of which is worth as much as the Lipitor patent. Software is a much more difficult business. I mean, the critics of software patents say that they're all small little things. You look at that iPhone and you see the way in which they're integrated. It's a little bit of this, a little bit of that. You don't have to worry about patent protection because there's so much substitutability of one kind or another. And my answer to that is you're being too nice to yourself. That what happens, I suspect, in the software space is that there's a distribution of patents, some of which are extraordinarily valuable, even if they're software patents, with fairly long durability, many of which are subject to much closer substitutability and so forth. As we talked about with Jay Keyson, if in fact you have heterogeneity of system, if you're talking about the little patents, it may well be that first mover advantage or trade secrets are going to be able to protect you. If you're talking about the really large and essential kinds of things, if they're freely imitated, there's going to be no protection whatsoever because they can be reverse engineered fairly quickly. And indeed, if you've actually patented them, you actually have to give best mode disclosures and so forth. So I think the answer is that my view is on the question of patent eligibility, I would think that you want very strongly to keep these things patent eligible. When it comes to the question of non-obviousness, the more distinctive it is with respect to the particular patent that you have, the more willing you are in order to protect it. And then there comes a point at which the things are sufficiently small that you don't. There will be this market area where somebody will say, it's probably worth my while to patent it, and it's probably worth the while of the patent office to reject it. But I don't think that that's going to be the dominant dominant case, because I think there'll be a lot of self-selection. That for the really small, short-term inventions, what you do is you don't rely on the patent system, you just put them in there. Why make the disclosures on the best mode and pay the fees if you can just use it? But the other thing I think which is extremely important is how it is when there are close substitutes you deal with this thing. Because remember, there's this constant holdout problem which people talked about in connection with eBay. And that's because the people who talk about this have read too much of Calabresi and Melamed and too little of the law. That is, the modification, the model which is put forward is either it's all injunctions all the time or only damages. So you either have an impenetrable holdout problem on the one hand or a hopeless valuation problem on the other, at which point you cannot begin to explain the level of rapid progress which has taken place in these industries. So what is it that you want to think about? You want to think about how you use compound remedial strategies. And so to some extent you give an injunction that goes 90% of the way and damages for the rest, and what that does in effect is it probably eases the holdout problem and reduces the valuation problem simultaneously. And if you go back to classic injunctions and nuisance cases and so forth, the way in which this was commonly done is we will enjoin you as of 6 weeks from today, and in the interim you pay damages by some kind of formula to be assessed. And if you're worried about a holdout problem and you just postpone the remedy and give a kind of super competitive compensation schedule in the short run, 90% of this problem will start to disappear. And it's only because you treat these remedies as being strictly dichotomous that it looks as though you have a nightmare holdout advantage under the eBay patent. And the failure of Justice Thomas to consider these intermediate solutions is in fact a discredit to the system. And what was so ironic is they said, of course they didn't do it, that they were just applying standard principles of equity. The 4 principles that they applied were dreamed up by somebody. They are not standard principles of equity. The standard principles of equity are the ones that I've stated. Start with an injunction first, and then at the edges taper it down and use cleanup damages in order to help it. And if that's the principle you use, all of this anxiety stuff which has come out since that case would have been obviated. There is a very strong lesson here, and I'm going to end on this note because I have to end. I said at the beginning, you talk about Blackacre and Whiteacre, high levels of generality. What is so wrong with the patent bar and most of the patent professional academics is that they don't know anything but patents. And so they kind of have to invent everything over from scratch. Whereas the injunctive relief damage question is one that's been engaged in for 500 years. And if you actually knew some property law, you would immediately realize that you're talking about this thing in a way which is incongenious with the basic framework. And so what happens is, for the intellectual work, I make the following claim on which I will end. The fact that I am not a patent specialist, but have done various forms of property in extenso, is a comparative advantage, even if I don't know the name of the case that you just cited to me. So thank you.